people, when it comes to the space that we operate in, I always say to delegates, I normally do about 40 to 60 of these seminars a year. I'm only at home about 40 to 45 days out of the year. You know, it was like last weekend when I got home, my dogs were actually barking at me. So yeah, I'm not at home that frequently. But people, when it comes to this space, it really requires you to become knowledgeable. It's not that we are expecting you to all become lawyers or legal practitioners or advocates, but you really need to make sure that you equip yourself going forward. It is competitive out there. We know that our industry is currently going through a bit of tough economic times. So everyone is fighting for every inch. We are seeing a huge amount of claims being brought by contractors. In some instances, obviously, employers need to defend those claims, but more claims than ever. I think we will all be surprised at the amount of adjudication and arbitration cases being heard currently and being ongoing. And yes, people, adjudication and arbitration is not, it's not cheap. Arbitration, expensive. I think I've made it my vision to see if we cannot resolve disputes and keep our disputes out of court. But yeah, even when it comes to arbitration cases, those are very expensive. If you take an average arbitration case, it will probably set you back between 200 and 350K in arbitration fees, and that is, and then obviously inclusive of your commercial support that you need in terms of drafting your claims, your reply statements, your hearings. So it is extremely expensive. So construction management, let's talk about construction management. Of course, another aspect within the construction industry, I think that is to a large extent misunderstood and often misinterpreted, especially within South Africa. Many firms have a construction foreman whose roles and responsibilities differ quite significantly from that of a construction manager. I always say that if there's one individual that needs to be extremely knowledgeable on these contracts, then it must be your construction manager. And obviously there are many legislation that now plays a role. I'll touch on that as we go forward. So these construction managers and construction project managers, people like yourself, professionals, are fundamental to the development of a project. I think I'm the last person to advocate the steps, obviously, that we need to work through in terms of the project lifecycle and so forth. But yes, our contractors are hugely dependent on your guidance. So the construction manager, and I'll talk a little bit about the differences, and the construction project manager are certainly not the same person. We've now also seen within our contracts that when it comes to these contracts, that the contracts have adopted the naming convention of the construction manager. For the first time, the GCC 2015 contract no longer refers to the site agent, but the construction manager. We frequently say that legislation doesn't impact these contracts, but we can certainly see from that perspective, the authors of that contract certainly did accommodate the Professions Act, specifically to the project and project construction manager's profession. So it's important to accurately define the two professions in order to get this far better understanding and what they entail. I think very often it's difficult for employers and developers to comprehend how many construction managers do you need, how many project managers do you need. These days we work with these very complex contracts, FIDIC and NEC, and they certainly are complex. If we take the migration from JBCC and GCC, we are seeing that those type of contracts, and I will never knock our CIDB approved contracts, very powerful contracts, but they are also quite an administrative burden when it comes to managing. And I always say to delegates that when you choose the contract, you better make sure that the project can afford the contract. You need to make sure that you've got enough resources, enough skill to assist you in the execution of that contract. If you take the FIDIC contract, for example, and maybe just making a reference to the Red Book, you will find yourself coming out of one reporting period and then immediately moving into your next reporting period. So you better make sure that you've got a good support staff around you. I normally say that when it comes to FIDIC contracts, you basically need 3 to 4 people to assist you in your contract administration. I spoke to the engineer during the examination and I asked him, do you know what your delegated authority is? And he said to me, well, and that dispute related to a JBCC contract, and he said to me, well, he's very familiar with the GCC contract, but he doesn't know what his authority is in terms of the JBCC contract. And I said to him, but ultimately, you know, your signature, your name is in the contract data. How can you say to me that you are not familiar with your delegated authority? And ultimately, I had to point him to clause 17 of the JBCC, and unfortunately, the principal agent never communicated that delegated authority to the engineer. So not a good position to be in. But yeah, not such a good reflection on both parties, principal agent and then the engineer. People, when it comes to, I think, the contractual relationship as well, in terms of these engineering and construction contracts, there's very little, I don't want to say responsibility or liability, but as far as these contracts are concerned, the strict privity of contract, and the engineer or the agent can only be held accountable as far as his contract, his professional services contract with the employer is then concerned. So very little liability from the actual execution contract then. So talking about the construction project manager, I think ultimately, you know, when it comes to the construction project manager, he's ultimately responsible for the project. He's overseeing the project with your construction manager normally reporting into him. So typically the old site agent naming convention, if I can call it that. So talking about skill set, what is it that we need from a construction management perspective? So I think, you know, we can find guidance in our contracts. Our contracts are pretty clear in their meaning. If you consider the deliverables, the fact that we need to build quality into the works, that implies that whoever manages the contract or the project, be it the agent or the engineer, need to be fully knowledgeable of quality requirements. So be it ISO, be familiar with quality standards, processes, be able to act with skill and care. Good negotiation skills. I think when it comes to our space, we are negotiating almost every minute of the day. When you get up in the morning, when you get to work, you are always in negotiation mode. So quality, negotiation, and then of course your skill, project management. And people, when I talk about project management, and I must say I can be a very direct individual because normally I Like I state, I'm normally at the back end of adjudication and arbitration proceedings. But it really requires the skill set that you guys have. And I'm not talking about the project management 3-day course that you would do down the street. It's about having a full understanding. I'm still very surprised every week when I talk to delegates and have these workshops and seminars, and I would ask the question, so what is the critical path on a project? And you would be surprised how many individuals actually don't know what the critical path is. When you talk about baseline and redlining and forward pass, backward pass, network diagrams, earned value, I think we sometimes think that, that everyone is knowledgeable out there, but in some cases it is not so. People, when it comes to these contracts, and I decided to specifically talk about these international type contracts, and then in the context of the project manager, the engineer, the construction manager, like I stated, they require individuals to be knowledgeable. So skill yourself up, get yourself a good commercial guide, get yourself these contracts. I still find it very surprising that a lot of our project managers and contract managers and construction managers, they don't even have access to these contracts, or they share a contract. I always say these contracts actually become used to you. If I take my contracts, they normally fall open on claims or disputes or adjudication or arbitration, but you need to have your own contracts. Looking at the competency then of the construction industry, I think as of late we've seen a number of dangerous and fatal incidents in and around construction sites within Gauteng. I think there were 1 or 2 also in KZN. We recently had one on our doorstep there in Somerset West as well. And so I think, that these incidents have really put a cloud of speculation on the competency of the construction industry as a whole. I often say to delegates that if you sit here today, and regardless of the type of contract that you're managing, so regardless of whether it's JBCC, GCC, FIDIC, NEC, if you cannot see your contract playing out in front of you, then you've got a real problem. A lot of these contracts, in my opinion, yes, they are extremely well documented, really very comprehensive, complete. I think all the authors of the contracts are really doing a great job. Yes, there will always be some grey areas, but our contracts are clear. So if you cannot see your project playing out on ground level, then you've got a real problem. And when I talk about our contracts playing out, I often stop at these construction sites and I would start to talk with the site agent or the construction manager or the construction project manager, and I would just ask a few very simple questions. These people moving in and out on site, who do they work for? I don't know. Machinery, tools and plant moving in and off site, who do that belong to? I don't know. Yeah, a real problem. So if you get a response like that, it basically means that you are not guarding against the risk of the employer. I always say to delegates that if you want to stay out of problem or out of a predicament and stay out of trouble in this space, you constantly need to put yourself in the shoes of a reasonable other contractor or the reasonable other engineer. We are seeing most of our contractors being found guilty, if you look at case law, of not having acted in a workmanlike manner. If you look at our professional or our professionals and our teams of professionals, they are normally found guilty of not having acted according to their profession. So these contracts, in my mind, are pretty simple. They've got some very basic underlying principles. If you need something, you ask for it. You give me time, here's notice. I always say that, when it comes to these contracts, you should be able to manage and execute a contract without the contract actually being there. If you look at our judicial framework, our whole framework is based on natural justice. And the concept of natural justice highly embedded into our contracts. When it comes to claims and disputes, my PA has been working for me, Tembi, I think now for 15 years. Not an engineer. She did a couple of secretarial courses, but every now and then we would be tasked to provide a commercial opinion, and frequently I would take that problem or problem statement and put it in front of her, and I would ask her, Tembi, what do you think? If you are just this reasonable man, what would your determination be? We don't need a contract. I think we sometimes make these contracts extremely complex because we overanalyze and we overinterpret them. I'm not saying don't play the game to the offside line. Yes, of course. It's not what the contract says. It is what the contract is quiet about. If we talk about natural justice, maybe I should just elaborate on that a little bit. So inherently, we as human beings actually know what is right and wrong. You don't need a contract to tell you that. If you take a young child, normally from the age of about 12 or 14 months, they start to move about. Certain children do that from 9 months already. But if you take a little bowl of candy, so on your desk there's a little bowl of candy. If you take that young little individual, he or she will walk to that little bowl of candy and will help themselves. But when you give them the eye, what do? They normally take the hand and put it behind their back. So inherently, we as human beings, we actually know what is right and wrong. But it seems that that judgment sometimes gets clouded. Ultimately, when it comes to the engineer or the project manager as yourself, there's an expectation that you need to conduct yourself as a quasi-arbitrator. Need to be this fair and neutral person. I know that it's a very difficult predicament to be in. In the earlier session, I could see that you as an audience were expecting some magic maybe from the presenter. How do we deal with riot, commotion and disorder? There's no magic. And the same applies to these contracts. Yes, you need to be knowledgeable of these contracts. You need to be able to defend yourself. Unfortunately, there's a lot of bullying happening in this industry. Sometimes both from the contractor and or a engineer and or a project manager. We are really seeing a lot of absurd interpretation. It was like last week, when an engineer rejected a contractor's notice of intent to bring a claim. Rejecting a notice of an intent to bring a claim. Yeah. But yeah, you cannot negotiate anything if you are not knowledgeable on these contracts. You need to be able to see your contracts playing out. And it's not difficult, people. It's not difficult. If you look at all of these contracts, and I always say to audiences that none of these contracts are in conflict with one another. Yes, in some cases, they've got a little bit more administrative procedures, a little bit more formalities, a little bit more provisions in the contract. But none of these four contracts are in conflict with one another. So the result of incompetent persons acquiring the roles of construction managers and construction foremen or foremans, fatal. We've seen the case of Straydon Park versus Abcon, a very popular case, a case being quoted quite frequently when it comes to, when it comes to disputes and arbitration cases. Straydon Park versus Abcon, that involved the building that collapsed many years back. I think it's the old Sammy Marks plane in Pretoria, where the judge actually asked the foreman, so what was your role? The construction manager, so what was your role in this project? Explain it to me. And the foreman responded and said that he was merely there to make sure that the work gets executed. He was not responsible for building quality into the works. And the judge ruled, said no. That's not what can be expected from your profession. Your profession. You should have made sure that quality gets built into the works. A lot of our contracts are actually quiet on quality. It applies care and skill and diligence in that context. Some of our larger and more international type contracts are more in detail when it comes to quality. But yeah, we are measured ultimately against our profession. Maybe just coming back to riot, commotion, disorder. People, that is a serious problem. We've had a couple of cases now in Cape Town as well. I don't want to be specific. But where a contractor and his foreman were held at knife point, locked up into containers, vehicles being driven away. And there's only so much that a contractor can do. Yes, ultimately you're responsible for protecting and securing the works. That will always be your responsibility. So in the boundaries, that is your responsibility. But ultimately what happens outside there, that is the employer's responsibility. They need to make sure that there's order. And the previous presenter certainly had it right when it comes to the duty of the client liaison officer. But it's complex and it's difficult. You know, frequently we see parties resorting to court for interdicts. Let's get an interdict against the community leaders, or let's get an interdict against the forum leaders. And in some cases, it actually just puts more oil onto the fire. But yeah, I think unfortunately, a lot of our employers expect from our contractors to go and negotiate. And I find that difficult to understand. But unfortunately, I'm a bit of a rebel. It's not that I'm pro the contractor, but I think you need to take responsibility for the area in terms of the contract, ultimately. Of course, negligence is also to blame when it comes to these accidents and incidents. I remember, while I'm standing here, a couple of years back, I was called out to the Grootvlei power station site. And they had quite a horrific incident there. Two contractors arrived on site, did not follow the safety protocol, did not insulate, did not isolate, and started to do work on a high-pressure steam pipe, and they were literally blown to pieces. 3 days after I arrived on site, some of the forensics and pathology departments and their personnel, they were still picking up body parts on the turbine floor. And it quickly became apparent to me when I drilled into the contracting strategy that even at the point of contract formation, that there were negligence. Those contractors should never have been appointed. Protocol was not followed. People, these contracts are serious. I think very often we consider them extremely lightheartedly. We enter into them, we then take the contract and we throw it in the drawer. And it's only when an event manifests itself, then suddenly we want to grab and look for contract clauses that can assist us. It is not the intention of the authors for the contract to be used in such a fashion. So maybe just talking about negligence. I normally do a one-day workshop on contract law first before dealing with these contracts. 2 or 3 hours are really not enough. But normally after 3 days, the delegates would normally say to me that they don't want to be involved with contracts anymore. It is certainly not my intent to scare you. But people, I think it's cynical to think that we can take young individuals and immediately throw them into the deep end when it comes to these contracts. There's obviously a lot of emerging contractors out there, and there's nothing wrong with that. We are constantly in development mode, but I find it so strange that we take young graduates and we immediately throw a contract at them. People that would know me would know my sayings, but I think before you can run with the big dogs and lift your leg, you first need to run with the dogs a little bit. So before you lift your leg, get educated, become knowledgeable. There are many tools out there. If I take the CIDB website, for example, and there are many other sources, there's so few people that actually pay attention to the CIDB prescripts. I always say that if you want to become knowledgeable quickly in this industry, you can probably work through those 29, 28 best practices in the evening's time, and it will certainly take you a long way. So talking about legislation, at some point in time, you would have to become familiar with legislation. You cannot say, I did not know. The other day I was talking to a group of emerging contractors, and they said to me, but Advocate Chris, you know, where do I find all this legislation? Yeah, there's many sources. LexisNexis, Utah law, we are now seeing that a lot of the contractors and constructors and engineers, consulting engineers, they now start to subscribe to these legal databases because things are really heating out or up out there. But as a contractor, you are expected to be knowledgeable of all legislation. You cannot say, I did not know. So at some point in time, you would need to go and read your own Professions Act. I find it so strange that frequently I would talk to project managers and they wouldn't even know about their own legislation that apply in their own space. So how on earth can you put an individual down to manage a site if you are not following regulations? Regulations obviously have quite a lot of priority next to legislation. So talking about negligence, and I think it's a concept that we maybe need to elaborate a little bit more. I think we have all been watching a lot of the public trials taking place right now. You know, I spoke to my wife over the weekend, and I think what is quite scary for me is that I think we are these days all affected by crime. You know, if you take a family and you talk about a family and a family environment, I think a lot of you would agree with me that we have all been affected or have in some or other form been exposed to crime. I feel it's a little bit out of control right now, but yeah, hopefully things can improve at some point in time. But talking about negligence, we've been exposed to a lot of court cases. The Oscar trial, for example, at one stage, prosecutor Gerry Nel said to Oscar Pistorius, but Mr. Pistorius, you are guilty of culpa. You were negligent. How on earth can you play with a firearm in a public facility, in a restaurant? How can you drive through a city or town and fire off shots? Who does that? Is that normal? I don't know. Maybe these days it is. But culpa, negligence, a big component in our contract world. We need to understand that all of these contracts that we are exposed to falls under the law of obligations, and always running hand in hand with the law of obligations is the law of delict. Blameworthy conduct to cause harm. Not acting, not responding, not doing something. Yeah. You are negligent. A couple of weeks back, an engineer phoned me, and we were just having a discussion. And while we were talking, he said to me, "Chris, can you quickly hold on? I've got a contract in my office, and he wants to find out from me whether he can work over the weekend." And I said, "Sure." And I could hear him in the background talking to this contractor. And ultimately, he came back into the call, and we concluded the call. 2 weeks later, he phoned me. He said to me, "Chris, can you remember that day when I phoned you?" I said, "Yes, you had a contract in your office. I remember you put me on hold for quite some time." He said, "You won't believe what happened. The contractor came in and he asked me whether he can work over the weekend." And I said to him, "Well, what was your response?" He said to me, "I didn't have a problem." And I said to him, "It's fine. You can go and work over the weekend." But he said to me, "You won't believe what happened. That contractor went to site, he de-established, he demobbed, took his plant, took the material, and off he went." So when he spoke to me, he asked me, "What is, or are there perhaps any liability for me?" I said, "Yes, Mr. Engineer. You did perhaps not address the right issue. Why didn't you ask the questions?" He said to me, "Well, at that point, there was no need to. You should have asked, why? Why do you want to work over the weekend? Is it a progress issue? Is it a delay issue? Is it a quality issue? Is it a labor issue?" So in that case, the engineer could be a project manager, could be a construction manager, can be found guilty of not having guarded against the risk of the employer. If you want to stay out of trouble in this industry, you always need to put yourself in the shoes of the reasonable contractor, the reasonable other engineer or project manager. And when it comes to negligence specifically, culpa, you need to show that you did not only guard against your own risk, but you've also guarded against the risk of the employer. Also in our space, the point of measurement for negligence is at a far higher priority. So in our case, as professionals, we will be measured against our Professions Act, our branch of our profession. So that is the question. That is your point of measurement. So if you want to test your own conduct, that is where you need to test it. It is not the standard measure point for negligence in the normal context of the word. If we want to look at the point of measurement for the man in the street, it is a far lower point of measurement. It is not the standard of exceptional skill and care. It is also not the standard of undeveloped skills and recklessness, but it's the standard of the ordinary individual taking reasonable precautions and chances. But in our space, that is the level of measurement. We need to conduct ourselves according to our profession. Case law, Randery versus Dixon. So the construction project manager, So Sacpcmp stated in the Guideline Scope of Services and Tariff Fees 2004 that CPM is defined as the management of projects within the built environment from conception to completion, including the management of related professional services. And the construction project manager is this one point of responsibility in this regard. So ultimately, people, when it comes to responsibility, yes, you can delegate, and all of our contracts are pretty consistent. None of our 4 approved CIDB contracts are in conflict with one another. Ultimately, the employer's agent or whoever that individual is that will be acting as the employer's agent will take responsibility. And not all the contracts also refers to the project manager or the construction project manager as the agent, only some of them, making only some of them subject to agency law. So pivotal and important role within the project team. So if we then look at the role then of the construction project manager, he then oversees the execution of the entire project, while the construction manager oversees the construction of the building. Not all of the contracts also refer to the construction manager. Some of them refer to a site agent. But some of the contracts merely states that the contractor needs to appoint a representative with the necessary skill to manage the execution of the works. The word execution is actually now a banned word. We can no longer execute anything in this country. We can only carry out the works. So we are seeing that some of the authors are starting to amend the language in these contracts. Talking about a positive influence on success of a project. Critical factor, eh? Law of attraction. Yeah. Positive influence on the success. I had a case a couple of months back, just thinking about positive influence coming from a construction manager. A director of a constructing firm or contractor phoned me and he said to me, "Chris, I need you to go and F up that municipality." I said to him, "I don't do that thing. It's not in my nature. But I will try and help you." So he explained to me the scenario that they were working on a resurfacing project in the Saldanha area, and apparently due to non-conformance and non-compliance, not executing the project within the parameters of the contract, ultimately the engineer or the project manager working for the city council informed the city council that he recommends for the contract to be terminated. Ultimately, the city council terminated, and ever since that termination, the contractor hasn't been able to procure new work. He said to me, "Advocate Chris, we feel being victimized. You know, that same engineer that was involved in that project, he also sits on the tender bulletin of the city council, and we feel that perhaps there's undue influence." And I said to him, "Well, you know, from what I hear, potentially it could be. But give me your project file. That for me is always the starting point. Is to pull the project files, look at the contract documentation. Critical. We'll talk about contract documentation as we go forward. A judge the other day actually commented to a contractor, and he made a remark in court saying that when he looked at the contract correspondence of the contractor, he could actually see that the contractor is a responsible contractor, acting in a workmanlike manner, by the way, how he keeps his document and documentation and so forth. But anyway, I went through the project file, And I quickly ascertained that the project manager, in this case, the engineer, he was extremely helpful. He did everything in his power to assist this contractor, constantly begging him, please, I need your new program, I need your updated program. Why are you constantly in delay? Where is your people? Why are you not performing? You are late. And then I looked at the responses coming from the construction manager, and I met with this individual. And all his responses back to the engineer was in this trend. Oh, Mr. Engineer, sure, we've been having some difficult times, but hopefully things will improve. We're going to get a new site agent, but hopefully things will improve. We're going to get more people, but hopefully things will improve. But I cannot promise anything. I cannot promise anything. Ultimately, the engineer turned around and said, I can no longer rely on hopefully. Hopefully is not going to cut it. And ultimately, the contractor got terminated. What was quite strange in that scenario was just looking at the events, how it played out. So around about 11 o'clock, the city council terminated that contract. And at about 2 o'clock, the contractor then also terminated the contract. I then said to the contractor, please explain this to me. So on the one hand, the employer terminated, and then you terminated. He said to me, Chris, you know, I got so mad that when they terminated, I also then decided to terminate. And I asked him, I said to him, but how do you want, or how do you expect me to go and defend you under arbitration? What will I say to the arbitrator? What would I say to a judge if you were to proceed into litigation? How do we defend it? Because ultimately, it doesn't look like any of the two parties wants to be involved or wants to stay in the contract anymore. It is in any case right. You cannot terminate if you yourself have been in a material breach of contract. But yeah, influence on a project. Looking at cost influence on a project, I think there's one very simple rule. As soon as there's any impact on cost or schedule or performance, we need to notify one another. It's as simple as that. Yes, there are certain time barring provisions, but if there's any impact on cost, schedule, or performance, let's just notify one another. That's it. If I look at the NEC contract and the FIDIC contracts, those contracts are really built on absolute transparency. If we talk about the NEC contract, and I know that I'm talking to a lot of experts here today, it is really the only contract where there's a duty on the project manager to inform, the NEC contract. The only contract where there's a duty on the project manager to inform. Oh, Mr. Contractor, bring me your claim. That's a compensation event. Bring me your claim. Yeah. None of the other contracts places that obligation on the project manager. So individuals like yourself, duty on the project manager to inform. When we talk about conflict, sure, we are seeing this environment being extremely hostile. Certainly this year, I think we've dealt with the most adjudications and arbitration cases ever in the history of our organization. And I don't think it will improve. You know, many years back, I think one would meet next to the road or in a pub somewhere and lay the drawings out and talk things through. These days, we are immediately seeing notices, substantiated claims being followed through on. So, But yeah, I think in a lot of cases we've actually caused a lot of these things. Contractors not being paid on time, not being paid consistently. And there could be many factors for that. And a lot of these things are not always in the control of the employer. And, sorry, let me rather rephrase, in the control of the project manager or the engineer or the employer's agent. When it comes to conflict and these contracts, our engineer, our project manager, our employer's agent is not always involved in conflict resolution. Some of our contracts leave the dispute resolution or the conflict handling to a third party. If you take the FIDIC contract, for example, the engineer, the project manager plays no role in resolving disputes. That will be resolved by an independent third party, an adjudication board. So the lock of all projects is closely related to the right prepared contract. Sure, people, I must say when it comes to these contracts, I think the industry are really moving more towards EPC type contracts. For the first time, I think now the past 18 months, we are certainly seeing more EPC type contracts, moving away from the traditional manner of contracting where contracts are employer designed. We are seeing our organs of state, Department of Water and Sanitation and so forth, and Public Works, etc., now turning to the FIDIC type contracts, EPC type contracts. So obviously, with those type of contracts, more turning and are looking for one single contractor, knowledgeable contractor, where there's maybe less hand-holding involved. So contracting, of course, an integral part of construction projects, and managing the contracts, therefore, is equally important for the success of any business process. And of course, people, you know, we are seeing a rapid increase in multiple contract types as well. And I think this is an area where our organs of state and parastatals, I think it's a difficult environment for them to be in. Yes, we have now gone through a period where there's maybe less projects. I think things will improve in the next 6 to 8 months. But when it comes to our contracts, you know, not only do we need to deal with these 4 contracts, but we are seeing various versions of the contracts, notwithstanding the standard for uniformity promulgating that we should be using the latest version of the contract or contract types. We are still seeing a lot of the older contract forms being used. I think yesterday we got an inquiry for an in-house seminar for a JBCC 4.1, and I was actually wondering, sure, why on earth would you still want to use such an old contract? But yeah, it certainly has to do with, I think, to a large extent, risk management and the apportionment of risks. We are certainly seeing, with the later versions of the contracts, a better apportionment of risks. People, so when it comes to these contracts, I think ultimately one needs to decide if you're going to manage according to the contract or whether you're going to do your own thing. It is very difficult to help anyone when you are walking next to that bike. I always say, you know, when it comes to these contracts, you see a lot of engineers and sometimes project managers and even contractors walking next to that bike. But at some point, you need to get back onto that bike. You need to start riding that bike again. You know, when it comes to these contracts, I think you will immediately know whether you are dealing with a knowledgeable contractor, and or knowledgeable project manager or engineer. It's very easy to come to that conclusion. At commencement, we know that a contractor is normally waiting for information. Similarly, if you're an engineer or project manager, you are also waiting for something to come from the contractor, whether it's a schedule or guarantee or demand bond, whatever the case might be. And if you don't get that request, then perhaps the party on the other side are not fully knowledgeable of their deliverables and their responsibilities. But when it comes to duties and responsibilities, these contracts are extremely well defined. I think if we look at the objectives of all four of these authors sitting behind these four contract types, then that was certainly one of their biggest objectives, and that was to really make sure that duties, responsibilities are well defined. So project managers are facing a lot of contract management issues. People, again, when it comes to these contracts, there are no quick fix. You know, I was listening to the previous speaker when it dealt with those scenarios of riot, commotion, disorder, impact of local forum leaders. There's no quick fix. Ultimately, you need to follow the contract. But make sure, at least, that you go back to the origin. If it's a quality issue, deal with it as quality. Your starting point in all of these contracts will always be the technical data. And the technical data or the tender data, that will provide you with guidance. And there are many deliverables. If you take a project manager, an engineer, an employee's agent, you've got approximately between 80 and 90 functions when it comes to these contracts. So if you are sitting here today, perhaps there's a couple of things that you still need to go and do afterwards. But when it comes to these contracts, there's approximately 85, 90 functions in terms of these contracts. And our contractors are also astutely aware of it. You know, for a contractor, it might be his only contract. For you as a project manager, construction project manager, perhaps you've got many projects, many versions of contracts, and that places you even at a higher risk. I think, you know, just talking about time management and these contracts, contract management, I think for me the biggest focus is really the administration behind it. But if we think about time management, and it's not a nice concept, but I think we need to understand that when we intend to use one of these four contracts, there's a good chance that your project will be delayed as a result of the contract type. It is not a nice concept to think about, but that is the reality. There's a good possibility that your contract or your project will be delayed as a result of the contract. And the reason why I'm making this statement is the fact that there's a lot of time barring provisions in this contract. If you take GCC or NEC or FIDIC, normally the contractor has 28 days to notify of a claim. He must then submit his substantiated claim within a further 28 days, and then ultimately the engineer or the project manager need to make a reasoned ruling 28 days later. So only 3 months later, we've got a determination. But it's not a nice concept, you know. It's not something that you want to say to the employer that you need to factor in more time. But there's a good possibility that your project will be delayed as a result of these time-barring provisions. I normally make the statement to say that if you use one of these contracts, you would typically like to build in maybe 4 to 6 months, just to allow for the contract administration to play out. We sometimes don't consider the effect of the time barring clauses on your schedule or on your program. So contract management, if we look at that definition, it says it's the active management of the relationship between the client and the contractor. So close privity of contract. A third party cannot enforce the obligations between the contracting party. Yeah. And then says over the term of the contract for the provision of goods and services to the agreed standards. The active management of the relationship between the client and the contractor. We are seeing, unfortunately, that some of our contracts are a little bit quiet as to the role of the employer. If you take FIDIC and if you take NEC, those two contracts are pretty quiet on the role of the employer. I think the JBCC is probably the most outspoken when it comes to the employer. Many things that the employer needs to provide, but I think ultimately the most important aspect is to make sure that the project manager or the principal agent feed the contractor with information. One of the most important aspects. The other day, also during an arbitration case, I was cross-examining an employer. And I said to the employer, do you actually understand your mandate in terms of the contract? And the lady in front of me said, no, I've got a project management firm. They're responsible for managing that interface. I said, but you signed the contract. Yeah, but I've never read the contract. You need to find a mechanism, and you need to make sure it's your duty that the principal agent stays on top of his game. The project manager stays on top of his game. Yeah. Yeah, I think a case that I really don't want to talk about is the case of Contractor while I'm standing here, Contractor against Tron Broers. The first time ever that the JBCC contract was measured against the Consumer Protection Act. And unfortunately, I was at the losing end that specific day. So what happened in that case? I sometimes think one actually learns more from case law as opposed to the theory when it comes to these contracts. And I've tried to do that also, and then the delegates would come back to me and say, but now we've lost the theory again. So, to try and get the perfect balance is sometimes difficult. But maybe I can just stand still for a moment and talk about the Contractor versus Tron Broer case. The first time ever that the JBCC contract was measured against the Consumer Protection Act. So Mrs. Contractor decided to build a holiday home in the Hermanus area. Quite a significant property, beachfront property with a very modern house. She went to go and see an architect, and together they decided on the type of contract, selected the JBCC Principal Building Agreement version 6.1. The work went out on tender, and ultimately Tron Broers tendered for that work. So I can talk about this case. It's a reported case. Tron Broers responded and was awarded the contract. So Tron Broers, a construction firm in practice for many years. I think they've been in existence for over 40 years this year. Well respected. And these guys really know their contracts. So the contractor commenced with the works, and at some point it was time for the fenestration and all the aluminium works to go in. The architect specified the glass thickness at 24 millimeters. she then specified the fenestration that I mentioned at, I think, 64 millimeters. And it was recorded as such in the window and door schedules. It then went to the specialist fenestration supplier, Glassman, who applied ARMSA and SAGA standards, and based on those standards, amended the aluminium dimension to 84 millimeter, and proceeded with the implementation, installation thereof. So on one given day, Mrs. Creer came to site, but something didn't look right to her. Walked around on site, and the dimensions and the fenestration then caught her eye. And she then said, but things look out of proportion. Ultimately, she turned to the window and door schedules and called the contractor and said to the contractor, there's something wrong here. The contractor did everything in his power to resolve this issue, had various technical meetings, brought the client and Glassman together, a nominated subcontractor. Ultimately, Mrs. Creer demanded for the glass and for the fenestration works to be replaced, 1.4 million. Tron Bruce, the contractor, said, no, I'm not going to do that. You negotiated with a nominated subcontractor. Glassman merely applied standards. You would not get approval for the property. You will not get your COC for the property if that was not the case or the case. And ultimately, the relationship soured, and ultimately, Tron Bruce declared a dispute. Mrs. Creer didn't respond. The architect also did not respond, obviously knowing that Glassman merely acted in terms of legislation, applying building standards and regulations, the 10400, and ultimately ignored the dispute notice coming from the contractor. And as a result of not complying or not responding, the matter then proceeded to adjudication. Mrs. Creer turned around and said, but what do I know about adjudication? I'm just a housewife. I've never been involved in adjudication. Ultimately, Mr. Tron received a letter from a lawyer in which he was told that he should have explained the terms and conditions of the building contract to the client in terms of the Consumer Protection Act. And on that basis, Mrs. Creer obtained an interdict to prevent Tron Bruce from proceeding with adjudication and arbitration. So this is quite a significant piece of case law. So obviously, if you are going to play in the space of private consumers, know this. There's a requirement on you in terms of the CPA. If you're the architect, or if you're the project manager, or the contractor, that you need to inform the client of his or her own contract. You need to sit with him or her and explain. I must say, on that given day in the High Court, Judge Dennis Davies, I was sweating, like you can't believe it. I really wanted to soften the blow for the contractor a bit. And he actually said to me on numerous occasions, counsel, please just give me something to work with. But ultimately I couldn't. Because he asked me one question. He said to me, show me in the definition of a transaction in terms of the Consumer Protection Act where it excludes a building contract. And it's quiet. It does not. So please be extremely mindful when it comes to operating in the private client space with our contracts. Many lessons to be learned. Consumer Protection Act. So suddenly, We had a contractor that found himself in very expensive litigation. Okay? A company that has never had a single dispute, suddenly, because of something like that. Yeah. But that is not where it stopped. The case is still ongoing. The next question would be, can a specialist fenestration specialist, can a supplier be held accountable for deviating from a design in order to comply with building standards and regulations? That is the next question now that will go in front of the court. So the contract lifecycle or contract lifecycle management, let's talk about that for a while. So we can see that as far as what that is, it's the process of systematically and efficiently managing contract creation, execution, and analysis for maximizing operational and financial performance and minimizing risk. I always say to our engineers, if you want to avoid a dispute, just pay the claim. That's the easy one. Just pay. Then there won't be any disputes. Disputes are normally as a result of an action or inaction. You either like my determination or you don't. But yeah, people, it's certainly not as simplistic as that. But I think ultimately, and having studied these contracts quite extensively, and I really don't like it when people refer to me as an expert. I know a little bit, but every day I learn more. I think talking about experts, we've all seen what happened in the Tim Noakes case, so certainly I'm not an expert, I know a little bit, but yeah, I often say to my wife, I wish I can go to bed just one night without having to read. Because that is what it takes. You constantly need to read, and equip yourself. But when it comes to, I think, to risk, my view on these contracts, fairly simplistic. I think from a contractor's perspective, you really just want to preserve your profit margin. That's really all that you want to do. You don't want to lose money. Or revenues, you just want to preserve your profit margin, and you want to be compensated for the work. And I think ultimately, if you're the employer, you want to make sure that you get the product within that triangle of cost, schedule, and performance, the quality criteria. When it comes to risk, sure, people, I think over the next 3 days, there will probably be a speaker that will be talking about risk. I think if I can use an example of how important risk management is, again, a case that was referred to me, the Malmesbury Swartland Hospital that burned down last year, March. So it was a betterment project. NEC 3 ECC contract was signed under a framework agreement. Luckily for the contractor, it provided for sectional completion. But on the 16th of March, if I remember the date correctly, the contractor was busy with insulation work on the roof, using these fire hoses. And the entire facility caught fire due to a gas leak in the roof. Luckily for the contractor, the Department of Public Works made a bit of a boo-boo in the construction of the contract. Although the contractor was responsible for the insurance, they forgot to amend the limit of liability under the NEC primary data, and they left it on 0.00. During that investigation, I requested the minutes of the meetings from commencement. And as I went through all of those minutes had a very nice little heading in it. Talked about health, safety, and risk. But nowhere during the entire contract life cycle were there ever any risk recorded. Never, ever. A live environment, live patients, not a single risk ever recorded. Unfortunately, the project manager is now criminally being proceeded against. Did not act according to his profession. So people, when it comes to these contracts and projects, you better make sure that you do risk assessments. You know, you guys have studied everything. I studied project management for a while, and then my eyes opened up, and so I've got a little bit of a different view on it. But there are still a lot of fundamentals. And one that we cannot get past is certainly risk management. How on earth can you work in a live environment? Here you've got a contractor that's saying to you, on that given day, I'm going to perform work in that area. And you do not pay attention. Yeah. But in that case as well, there were a couple of things not so nice, specifically related to the appointment of the health and safety officers. It came to the surface that the health and safety agent of the contractor and the health and safety agent of the department worked for the same employer, unfortunately. So people, when it comes to risk allocation and these contracts, in my opinion, the employer carries most of the risk. If you had to write up all the risk of the employer versus the risk of the contractor, you will find that the risk of the employer outweighs the risk of the contractor significantly. Almost 2.5 pages of risks. So there are many things that you need to attend to on a daily basis. I always say that if you want to be effective and efficient in this space, you can really not handle more than 2 or 3 projects at the same time, specifically when applying these contracts. And then, you know, a lot of the organs of state are saying to me, but a lot of project managers are having 24 and 28 and 30 projects. Geez, how effective can you be? Yeah. In my mind, a project manager should at least every week get out to site. There's going to be coordination work. There will be some administration work. You're going to phone. You're going to have meetings, either on site, off site. A lot of coordination work. At some point, come Thursday, Friday, then you need to update your project files, your schedules, and so forth. So very difficult to do more than, I think, 2 to 3 projects at the same time. So therefore, the crumbs will fall. The crumbs will fall. And for a contractor, all that a contractor needs to do is, he needs to watch the clock. Tick, 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 claim. Tick, 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 claim. Yeah. But certainly people, yes, I'm not all about claims. Not in the space where I come from. So, when it comes to the construction life cycle as well, we are seeing that a lot of our contracts are also structured in a bit of a construction life cycle process. I think if you really understand and take the intent of the authors of these contracts, reputable individuals and constituents who've contributed to the development of these contracts, you can certainly see that they are guiding the contractor. They're actually saying to the contractor, you need to do these things now, because later on there could be implications. If you look at all of these contracts, it starts off with definitions. It then deals with the tender data or the technical data, tender data. It then talks about the site visit. It then deals with ambiguities and discrepancies. It says, well, perhaps there could be a discrepancy, and then we will deal with it in this fashion. And then it runs into the role of the employer, the contractor, and it covers the rest. Variations, insurances, and things like that. Yeah. Ultimately, claims and disputes. So at startup, I actually wanted to leave it for a little bit later. But let's talk about startup when it comes to contract management. Setting the tone. People, we need to realize that the authors have tried their best in these contracts to guide the parties. You first need to do all of these things, and in some cases, yes, there might be a claim, there might be a determination, but the authors have really tried their best to cater for each and every scenario. But it was sort of impossible. I mean, these authors wouldn't know about all these projects playing out. So somewhere along the line, the engineer or the project manager, if you are using the NEC contract, you could also be the project manager in GCC, if you have those credentials that the contract expects from you, requires you to set the tone. What does that mean? It means that we need to explain to the contractor how we're going to manage this contract. And for me, it's one of the biggest reasons why contracts are failing and why we've got such a hostile environment. Yeah. Parties throwing contract clauses at one another. I think the last 2-3 years, if you really look at it, the amount of trees that we're chopping down as far as throwing contract clauses at one another. Eh? Setting the tone. So when we set the tone, we explain to the contractor what our expectations are. This is how we're going to manage the contract. This is how we're going to work with one another. This is what I expect from you in terms of notifying. Don't just think you can bring me a claim. If you need more information, come and talk to me. If you find ambiguities or discrepancies, come and talk to me. Yeah. But it's because we don't do that. It's because we are not setting the tone. And then the contractor doesn't have a choice. Then he will come and he will throw contract clauses at you. We need to understand that ultimately the engineer or the project manager need to start setting the tone. This is how we're going to work together on this project. We cannot just think that the contract will execute the project for you. And I sometimes get that impression. You cannot execute the contract from the back of your laptop screen. And then also the tone. Sure. You know, I sometimes look at correspondence and then it's in this tone. Oh, Mr. Contractor, in terms of clause 1.3.5.2, I still haven't received your first schedule. And we hereby reserve our right to terminate. Huh? Or a piece of correspondence coming from a contractor. Ah, Mr. Engineer, in terms of clause 1.3.5.2, I still haven't received your first instruction to commence. Yeah. We will never get it right if we remain on that path. I always talk about a diplomatic request. Tone it down. Set the tone. Yeah. Ah, Mr. Engineer, In terms of clause 1.3.5.2, I still haven't received your first schedule. Do you have the right email address? Maak hom so 'n bietjie sagter. Just tone it down a bit. Set the right tone. But it's because we merely rely on the authors in these contracts that I think we are going wrong. And then ultimately, we don't have a choice. Let's talk about ambiguities and discrepancies just for one moment. So all of the contracts allows for the parties to deal with ambiguities and discrepancies in contract documentation. It entitles the contractor to a claim. So if he finds anything different from the time of tendering to the point now, the contractor is entitled to a claim. Most of our contracts have a clause that says that the contractor is legally deemed to have based his tender price on the tender data provided. And if it results in an extension of, or if there's any impact to practical completion or proven additional costs, then the contractor is entitled to a claim. But by setting the tone, you can avoid that claim. You can say to the contractor at kickoff, Mr. Contractor, if you do find any ambiguities or discrepancies, first come and talk to me. First come and talk to me. The contract allows for the engineer or the project manager to provide interpretations and clarifications. Don't just think you can bring your claim. No, come and talk to me. The FIDIC contract specifically talks about that. If you pick up any ambiguities or discrepancies, come and talk to me. Remember, when it comes to these contracts, you will also find that they are not sequenced. It doesn't say, well, you start off here, and then you go there, and then you must do this. Yeah. It talks about a little bit about concept phase and definition phase, but in terms of that hardcore practical stuff, you won't find in the contract. And it relies so much on the experience of people of your caliber. Yeah. And I think, this is the great thing of these conventions. They are so important because we need to start talking about these things. Why are we seeing so many claims? Why are contractors not getting paid? Where are we going wrong? Yeah. And these forums open it up. It opens the floor up a bit. Startup. You also need to manage the process relating to unresolved issues. Yeah. I'm now dealing with an arbitration case whereby a contractor brought 25 notices. He brought 25 substantiated claims, not one determined. Not a single notice was responded on. So ultimately now, the contractor doesn't have a choice. We now need to proceed to adjudication or arbitration to get those determined. Yeah. Sometimes our engineers, our project managers also just stay quiet. Let's talk about the Stevel engineering case. I can really only talk about case law, because that is what passes my desk every day. If we take Stevel Engineering, it's now public knowledge that that company went through business rescue and was finally liquidated 3 weeks back. But why? So they signed two contracts, one for $51 million, the other one $48 million for the manufacturing of these gas vessels in Mozambique. The CEO phoned me and he said to me, Chris, I've signed 2 FIDIC contracts. When I looked at the contract, it smelled like a FIDIC, but it was not a FIDIC. It was a bastardized EPC silver book. Sure, I need to carry on with our slides, eh? So it was a bastardized EPC contract. And if we look at where things went wrong, it was as a result of the design review period in that contract. The FIDIC contract allows for a 21-day review period for design. Yes, you can amend it. So when Stivell did their planning, they did their planning for reviews based on packages or systems. That is not what the employer's agent had in mind. For him, he interpreted that design review period as having 21 days on each and every drawing. People, it is the small things that causes disputes. It's not the big things. It's hardly ever a design issue. Hardly ever. It is the time to respond, not responding, time barring provisions, not complying with the formalities of these contracts. 98% of the cases that we deal with are the small things. So what happened? Stivell tried to satisfy. Let's satisfy, let's play the game. And ultimately, they ran out of schedule. They ran out of program. And then it was too late. And in April of the new year, 2017, the employer decided to call the bonds. He called in the bonds. $16 million. How do you recover from something like that? You will probably work for the next 10 years without seeing any profit or any benefit. Good guys, good people. A well-managed organization, but they tried to satisfy the employer. Didn't want to bet, didn't want to play the game hard, but yeah, bullied. So we tried to prevent the bonds from being called, worked through the night, a weekend, and brought an urgent interdict. Because the employer was also in default. Haven't been paying Stivell for many moons. And the judge said to us, sorry, but when it comes to the bond, I need to put my focus and attention to the wording of the bond itself. Doesn't matter what happens in your contract, whether there was breach of contract, unless in a case of fraud, of course, and so forth. But yeah, I must interpret the wording of the bond. There were many claims, I think, till today, I think there's about $19 million of claims, but the company's liquidated, and they don't have the funding to go and pursue those claims. Because why? If you take Mozambique, it's not a common law country. It's not a common law country. Nothing is urgent in Mozambique. If you want to bring an urgent application, you need to submit your application, and then the court have 30 days to decide whether it is urgent. And they will then let you know that yes, they agree it's urgent. And they've obviously issued a decree about 2 years back stating that all work on the soil of Mozambique will be subject to Mozambican legislation. Being a non-common law country, it also makes it a little bit more difficult. The judges in Mozambique, for example, will purely give you interpretation or make rulings based on legislation. And that is why they don't follow the doctrine of precedent. So case law doesn't mean anything in Mozambique, for example. And that's why you will have different rulings on very same matters. When it comes to the administration of these contracts, people, like I said, you need to decide if you want to manage the contract or not. It is very difficult for you to be helped if you do your own thing. You must also please bear in mind that being a project manager or a construction manager or construction project manager, if you step away from the contract, if you write contract, because we are seeing that a lot as well, we are seeing a lot of absurd interpretation, and we are seeing a lot of contract writing. So during execution, we are seeing contractors and engineers writing contract. About 4 weeks back, I was in an arbitration case where for the first time, the principal agent stood up and said, but I now want side diaries. And I said to him, you never asked for side diaries in the beginning. It was never part of the tender data. Yeah, but it's straight usage. I said, well, prove to me it's straight usage. So something can only be considered trade usage if that specific contractor does that specific work repeatedly, and if it can be proven. Otherwise, a diary is just hearsay. It needs to be V&V'd, verified and validated, and you need to do so quite soon. Otherwise, a side diary doesn't mean anything for me. And I must say, when it comes to side diaries, I don't want to go into specifics, but a lot of these side diaries are not even worth the paper that they are written on. Luckily, the construction regulations also comes in, but because we are not knowledgeable of construction regulations, that also is left outside. And that is why a lot of our contracts specifically say, well, you need to keep a list of all people moving in and off site. You need to keep a list of all plant and material coming on site. The construction regulations supplement that by saying, well, you need to keep a list of all subcontractors also on site. And that is the only way how we can defend a claim or prove a claim. Performance. We need to think about these key words in these contracts. And people, I will pick up the pace shortly. I'm on a roll now. I'm settling in now. When it comes to performance management, we need to understand the key words in these contracts. There are key words in these contracts, but it's like we don't see it. Performance. So, performance runs hand in hand with obligations. You need to perform. And once you've entered into a contract, you cannot then say, I cannot perform. And that is why sometimes, and we are now seeing it more frequently, not only are contractors bringing claims based on the contractual provisions, but they are also bringing claims based on common law. Prevention of performance. I'm being prevented from performing. I'm not getting paid. I'm not getting paid on time. Others working close by or near to. Interference or obstruction, etc. Or performance not being possible. Sure, we currently have a couple of very problematic contracts. I think our dredging contracts are extremely problematic. I've seen some of our dredging contracts that went out to tender now. Payment is based on survey. You will not get paid. You will not get paid. And when I look at the content of those scope of works, there's no consideration for the dynamic of ocean movement, and it's a mess. Yeah. But let's talk about these keywords and wrap that up. So when it comes to these contracts, there are some keywords, and they come from somewhere. They come from contract law. Skill, care, diligence, preventability, foreseeability, obligations. And that is why you find those keywords in these contracts, because the authors are actually guiding you. It stems out of contract law. They're guiding you. Be careful of doing something now, or look at something now. It's like all the contracts talks about visiting the site, inspecting the site, examining the site. You need to walk around on site. Yeah. Because if you don't do that, or perhaps if you've done it, you can have a claim or not have a claim. Yeah. So performance management. So one fundamental principle of performance management is the fact that we need to proceed industriously. That is a basic principle of these contracts. We need to proceed industriously. No wait and see. Regardless of a program being approved, you need to proceed, Mr. Contractor. Yes, if the contractor is then maybe instructed to change his program or reschedule or resequence, then he's got probably an entitlement to a claim. You've wasted my time, Mr. Engineer, Mr. Project Manager. Yeah. But we need to proceed industriously. So people, when it comes to these contracts, how many times do these contracts forgive you, if I may ask? How many times do you forgive a person?
7 times 77.
You see, can I take your wife out for dinner tonight? People, when it comes to these contracts, I don't need to beg you. If I need something, I will ask for it. I don't need to ask you twice. But you need, as a project manager or as an engineer or as an employer's agent, you need to make those rules. And of course, at project kickoff, you're not going to say to the contractor, I will forgive you 3 times. Yeah, no. You keep it for yourself. When it comes to these contracts, and you know, people, I come out of the project world. I was involved in the refurbishment of 3 power stations for 15 years, and we then opened up the practice a couple of years back. But I think we need to understand that there's many engineering and construction practices as well. Eh? There's another component that comes with these contracts. Engineering construction practices. It's actually a pity there's no university where you can go to actually learn this stuff. How do you de-establish? How do you deal with the previous speaker's subject? Riot, commotion, disorder. You know, if you drive through the Delft area where we're currently building a number of RDP houses, it's not strange to hear gunfire. It's not strange. But there's no study guide. It's almost like contracts. And I find it so strange, you know, that within our education system, we don't teach our children about contracts. However, the first thing that you would do, once you leave school, you would sign a contract. But nobody ever teaches them about contracts. But we will learn through error and trial. The project and construction, or the project manager and the construction project manager, you've got a role to play in disputes. And therefore, you need to have the right characteristics. The GCC guide, for example, talks about this engineer or employer's agent having the characteristics of a quasi-arbitrator. You need to be impartial and fair. It's almost like cold and flu, eh? We're not always sure what is what. Impartiality has to do with your approach to something, and fairness, in my opinion, has to do with your decision. So the benefits of successful contract management. Obviously, people increase control, increase effectiveness, obviously reduce costs. I've already spoken about the fact that as a contractor, you really just want to preserve your profit margin. Talking about the strategic and competitive advantages. I don't always think that we consider the competitive advantages of successful contract management. So obviously, if you're an employer, you want to prevent disputes, you want to prevent claims. As an employer as well, you want to be informed timeously. Timeously is one of those grey words. We see all these contracts talking about the timeous provisions of drawings and instructions. Alfred McAlpine case, very quoted piece of case law. For me, I sometimes get the impression that we are losing the strategic intent of contracts. Do we really ever go back and consider what was the client's strategic intent? It seems once we've signed the contract, we are merely focusing on execution. I think as project managers, we will agree. And for me, having played in this industry also for a little bit of time, for me, everything starts with a need and objective. And that needs to be satisfied at the end of the day. So it enables both parties to meet their obligations. So people, when it comes to obligations, we are actually saying these days that we are becoming less reliant on the opinion of the engineer and the contractor. And the reason why we're saying that is, ultimately, the schedule or program provides us with guidance. That is ultimately what will give us an indication as far as progress. And when it comes to all of these contracts, you've got roles, duties, and responsibilities for the employer, the contractor, and ultimately the engineer. And that is normally the first thing that you want to go and have a look at. What are those duties and responsibilities? Talking about relationships. I think if you have worked with these contracts for some time, you will notice that these contracts are quiet on the relationships. It doesn't talk about relationships, except maybe the NEC contract under clause 10.1 that says that the parties must conduct themselves in the spirit of mutual trust and cooperation. We are now seeing contractors bring claims against the PMs for having not acted within the spirit of mutual trust and cooperation. Meaning this, if you understand the NEC objectives, absolute transparency. Absolute transparency. But these contracts doesn't deal with teamwork. It doesn't say, this is how we're going to work with one another. So ultimately, it again relies on the engineer or the project manager to set that tone. How are we going to work with one another? If you need something, ask for it. Give me timeous notice. If you get it later, or if you get the incorrect or omitted information, yes, then you can claim. Yeah. Tell me, how are we going to work with one another? These contracts are quiet on teamwork. There's a lot of carrot and stick. If you don't do it, there will be a penalty, or if you don't do it, there will be damages. Yeah. So we just need to think about these things. And again, people, when it comes to this area, this space, it requires you to be detail-orientated. if you're not a person that don't like reading, you've got a problem. Unfortunately, somebody has to do it. If you've done a proper review on a contract, there should be roughly be between 100 to 150 comments in the margin. That's if you've done a proper review of a contract. You will open up your bill of quantity, open your contract next to it, and quickly run through it. Oh, the contract says I need to restore the environment. I need to take it back to what it was as at commencement. Oh, but the bill of quantity is quiet on that. Question mark. Geez, you know, I need to outsource. There's a forced contracting strategy. I need to make use of local people. But on the other hand, the contract says your people need to be competent and efficient. You need to build quality into the works. How will I achieve that? And ultimately, the contractor remains responsible. Managing proactively. Sure. So people, the time barring provisions forces us to manage proactively. So there are many time barring provisions. And really, I don't think it's the intent of these type of workshops to teach you what the time barring provisions are. So I would like to think that you would go back and you would study your contracts further. But some of these time barring clauses are extremely long. If you're running obviously a shorter duration contract, then you need to make an adjustment. It would also be cynical to think that a contractor can wait till day number 27 before he notifies. Yeah, no, Mr. Contractor, go away. You've actually caused me more harm. You should have notified. And normally there's a rule. As soon as you become aware, or ought to have become aware of, you need to notify one another. I think for me, if I just look at some of the next bullet points, resolving disputes and so forth, for me right now, it's quite disturbing how little effort we are showing to resolve disputes. What was the case? Public case. Mfura Projects versus the Kuga Development Corporation. I hope I'm not targeting a Kuga person here today or this afternoon. But it's a reported case. So Mfura was appointed to do debushing of an area. The quantities, the estimated quantities was not correct, and it resulted in a far larger area being debushed. The total value of that service amounted to 564,000 rand. The engineer proved Kuga didn't want to pay. The case ultimately went to arbitration. Ruled in favor of Mfura Projects. And we of course know that when it comes to adjudication and arbitration decisions, those decisions must now be implemented immediately. No wait and see. Must be implemented immediately. So after the determination, Mfura Projects forwarded an invoice to Kuga. Now with the claimed amount together with the interest from date of award. The parties agreed that the ruling will be final, binding, and not subject to appeal. On the receipt of the invoice from Mfura, Kuga responded, "We're going to appeal the decision. Court papers will be served on you shortly." Mfura sat back, waited for the court papers to be served on them shortly. A month went past, and again, Mfura issued a new invoice. Again, they received an email. "We're going to appeal the decision of the arbitrator. Court papers will be served on you shortly." They sat back. Another month went past. Again, the contractor issued an invoice, same story. "Court papers will be served on you shortly." And after 9 months, I said to the contractor, you can not wait. You can wait no more. So we proceeded to the High Court in the Eastern Cape to get that arbitration award made in order of the court. And as I stepped up the stairs at the time when I was still doing litigation work, I received a call from Kuga asking me for my banking details. And I said, sure, I'm an advocate. We don't keep trust accounts. But it's a little bit too late. We've been trying to get this money from you for the past nearly 3 years. They also did not send any representation on that specific day. And the judge heard the matter in her chambers. It was over quickly, 2 minutes, I think, 3 minutes. So the original amount claimed was 564,000. With cost, the contractor walked away with 1.465 million rand. Just below the induplum rule maxim. Yeah. So in some cases, we are seeing that this appears to be very little effort or maybe an intent to frustrate. And I must say, people, that we've got a lot of contractors on the verge of insolvency. They cannot afford adjudication and arbitration. And even if you do proceed with adjudication, it's still going to set you back between 100 to 200,000 rand in adjudication costs to get those notices properly drafted and responded to. It's extremely expensive. This morning, when I caught the flight from Cape Town, I actually got a mail from a contractor saying to me that some or other adjudicator is now asking fees of 275,000 to make a determination. Absolutely absurd. 275K, jeez, ridiculous. Either the matter is extremely complex or there's many matters in dispute. So people relationships, obviously we need to balance our costs and managing these relationships. I think for me, a lot really depends on individuals like yourself. I think be firm, stay focused on the contract, and use the contract. We are now also seeing a predicament whereby if you do not rely on the contract, so you don't use the contract, I've had a couple of cases now in Cape Town where the principal agent said to the contractor, don't bring me your claims now, we will deal with it later. And when the contractor brought his claims later, the principal agent then said, but now you're time barred, you should have brought them 8 months earlier. Yeah. Now wait and see, you cannot gain time. You need to deal with claims and disputes within the current reporting period. Now wait and see. Yes, if there's maybe an event that keeps on repeating itself, you need to keep on notifying until you can obviously substantiate it. But yeah, it's for me always so strange, in certain months, we've got 10 of the same. Unbelievable. No, don't bring your claims now, bring it later. We'll deal with it later. Set the tone, people. So, continuous improvement in performance. So people, that is really only something that we can aspire to. But it really requires attention to detail and the fact that we need to be extremely responsive. And ultimately, we need fairness. I don't need to tell you what is right or wrong. It's like my eldest son said to me, Dad, please allow me to make my own mistakes. So I said to him, well, that is fine, but don't expect me to obviously assist you when you make those mistakes. Yeah. So people, yeah, regardless of culture or race, we all have the same challenges. Eh? You know, 4 years ago, my then 12-year-old daughter came home one day and she said to me, "Dad, I've got rights." Yeah. So certainly from that point onwards, I took cognizance of that. And from that point, I treated her differently because I understood that she understands that she's got rights. Yeah. So these days we need to care for our children until they are self-sufficient and self-supporting. Doesn't matter whether they are 18, 28, 38 or 48. Eh? I remember coming home a week after I wrote my final matric exam. I was working at, I think at Checkers at the time, doing packaging of goods and behind the cash register. And I got home around about 2 o'clock on that Friday afternoon, and I saw 2 suitcases standing at the back of the kitchen door. And I walked up the driveway and I thought, geez, it's going to be a great weekend. We've got visitors. And we're probably going to have a nice braai, and we're going to, you know, I already formed this little picture in my mind of it's going to be a great weekend. And as I wanted and walked past these 2 suitcases, I found my dad standing in the doorway. Coming out of an extremely conservative Afrikaner family, my dad said to me, "Hey, where are you going?" And I looked at these 2 suitcases and I realized my dad had different plans for me. So he took off earlier the day and he packed up my entire room and he only left me my essentials in these 2 suitcases. And he said to me, "It's done. Dis nou klaar." Yeah. So for 3 months I slept on top of my clothes and underneath my clothes until I could afford my own bed. But yeah, for many moons we were not a happy couple, but now I understand. It's certainly not something that one can try now. Morality have changed, eh? Things have changed. And morality shifts. Cannabis. Mr. Prince was a Rastafarian. Right? What was that case law? 1989, 1990. Completed his articles, wanted to enroll for his articles, applied at the bar. Now, in order to practice what we do here, you need to be found a fit and proper person. So Mr. Prince declared and said that as part of his religious practices, he uses marijuana. Sure. That, he shouldn't have done that. The bar looked at it and said, "Geez, Mr. Prince, if we allow you to practice, most of the attorneys and advocates will be high most of the time." And ultimately, the matter proceeded to the SCA, and they agreed. The judges obviously thought, geez, if we allow this attorney to practice, most of the judges will be high most of the time. But yeah, they denied him his application. However, now, 30, 40 years later, now it's good. 15 years ago, marriages between same-sex couples were not allowed. Now it's good, and we follow that. Yeah, so certainly religion plays an important role when it comes to legislation as well. So talking about terms and conditions. It's almost like in a time of war. Eh? We are all against war, I think, and we are all against murder. Do you agree? But in a time of war, it's okay. Then I will pick up my weapon and I will shoot the guy on the other side of the fence. We're probably praying to the same God, but hopefully my God will not be on my side today. Yeah, and then you wonder about these things. Eh? We are now seeing on Carte Blanche, there was a program whereby they are looking at maybe legalizing assisted suicides. Is that anything different than abortion? Let me not get carried away. I don't always understand legislation. On the one hand, you know, when you turn 18, you can get married. But wait, perhaps you might not be able to go and buy your own alcohol anymore. For that, you would need to get the consent of your parents or maybe go with them. But it's okay to have babies. But alcohol, that's a problem. We need to look at that one. So, terms and conditions. So, of course, people, when it comes to terms and conditions, we know that our contracts have many terms and conditions. Tacit and implied. Implied term, I don't need to tell you how to operate a wheelbarrow. It's implied. Or expressly agreed. Terms and conditions. I always find it so strange, you know, that we want to manage these contracts, but we've got no idea about Contract Law 101. How on earth do we want to execute these projects without first having a little bit of knowledge around contract law? All of these things comes out of contract law. There's reasons why we find those words, those basic, those fundamentals. But we take these young engineers and we throw a project at him or her. At night, when that individual returns home, he goes and sits at his parents' dinner table. It's a problem. You need to build a contract that identifies clearly the obligations. So people, when I talk about all these specifications, so obviously primary data and secondary data all included in the contract. Damages, your primary remedy for breach of contract. Normally either damages or penalties. Cannot have both. And you can only claim damages if you suffer damages. The project. Your project must be able to afford the contract. I've already stated that. I sometimes find these lesser value contracts or smaller duration contracts, and then we throw these very complex contracts at these projects. The project must be able to afford the contract. Formalities. It says firm, formal, and legal foundation. Yeah. And that is why all of these contracts talks about the provisions of the contract. And that a contract clause can never be contrary to legislation. Firm legal basis. Our contracts also typically says that if at some point a provision becomes contrary to legislation, then the parties need to sit down and they need to agree on a new provision. Yeah. But we can never have a clause that's contrary. We saw the case in Umtata, where the author of the contract decided in a GCC contract that he's going to remove the dispute resolution clause out of the contract. Yeah. And when I questioned the engineer, I asked him, geez, what went through your mind? He said to me, very little, unfortunately. He then responded. He said to me, it was a short duration contract, 6 months only, and in his opinion, there was no risk of a dispute. Well, 300,000 rand later, after approaching the High Court to get the amendment null and void and re-invoked, for the cost of the employer. Need to have a little bit of understanding about commercial law. Get yourself a good study guide. You're going to need it. This kitchen will only get hotter. And if it's too hard, get out. Go and do something else. It is what it is. You need to be knowledgeable on these contracts. Talk to one another. Share with one another. Get interpretation. Remember, people, there's an expectation on you as a project manager. What is the definition of project management? Should I ask what is the critical path? Yeah, so maybe it depends on the methodology that you are using, but yeah, the application of knowledge, skills, tools, and techniques in order to achieve, Yeah. You know, it's so strange when it comes to project management. It's actually something that we do in our everyday life. Every minute of your day, we do project management. A couple of years back, I did a seminar or a workshop at the department or at the nuclear energy regulator. And I was trying to explain to the grouping in front of me that actually we do project management every day. And I used the example, I said, you know, you set your clock at night. You get up at 4 o'clock or 5 o'clock, and then you normally have a quick chat with your wife, and you come out, you go and make coffee, or, you know, we've got the arrangement. She makes me coffee during the week, I will make a coffee over the weekend. I'm not a morning person. I'm bad news in the morning, so don't ask me to get up. But, so I went through the scenario, and then I said to them, and, you know, at some point in time, you go for a shower, and it will take you 2 minutes. And then one of the ladies got up and she said to me, but sir, it depends whether I shower alone or not. So ever since then, I decided not to use that example anymore. Anyway, so one needs to be careful, you know, what you talk to about these seminars. The other day, a delegate asked me, what is the difference between a green paper and a white paper? So yeah, you know, you get strange questions. Certainly not the color of the paper. Expect sometimes a lot from a facilitator. Should be flexible to accommodate changes and variations. This is what we want in a contract. So if we look at flexibility, for example, NEC, that was one of their main focus points, to create a set of contracts that are extremely flexible. So if you look at NEC, they've got the widest range of contracts. We'll talk a little bit about that more. So good contract management goes much further. Friction between different perspectives and approaches. Yes, people, sure. Interpretation. Interpretation is currently a massive obstacle in our space. Read the contract for what it is. It's the other day, an engineer phoned me and he said to me, Chris, I'm being told that I'm in breach, a contractor phoned me. He said, Chris, I'm being told I'm in breach of contract. My site agent, now the construction manager, he's not on site permanently, I'm being told. Well, whoever told you that has it wrong. The contract only says that the site agent must be on site while work is being executed or carried out. But perhaps there's a grey area. It doesn't say he must be always or permanently on site, only while work is being carried out. Roles, responsibilities, I think I've dealt with that. People, really, when it comes to our contracts, well defined. I wanted to become an engineer, but my mathematics were not good. When I was in Standard 4, my teacher actually called my parents and said to my parents, sure, Chris, he's probably the dumbest kid on the block. And when he's got the opportunity not to take mathematics, he should not. But yeah. And I learned a very valuable lesson. You know, about, I think it was 6 years ago, I went to my high school's 20th year reunion. So now you know how old I am. I'm fairly aerodynamic now. I used to be good looking then. But as I got out of my car, I walked up to the group, and one of my ex-girlfriends recognized me, and she walked up to me and she said to me, "Hi Chris, I'm married to an engineer." That gave me a knock, I'm telling you. I got home that day and I said to my wife, "Today I realize I'm in the wrong career." But yeah, she said to me, didn't even ask me, "How are you doing?" But I congratulated her. I said to her, "Well done, I'm happy for you." Yeah. I'm married to an engineer, I will never forget those words. No, people, I've got a lot of respect for you. So the importance of contract management, people, I think, yes, there's increasing pressure on all the parties to obviously reduce costs. You know, one of the topics that were discussed earlier today, right, commotion disorder, that is really putting a lot of pressure on already margins that are in distress, I think. New regulatory requirements. Of course, if there's any changes in legislation, it entitles a contractor to a claim. NEC goes as far as to state that if there are changes in tax structures of the employees of the contractor, then he can also claim. But yeah, obviously it can also have the reverse effect as well, and to the benefit of the employer. So automation and improvement, I think we're still far away from that. I know that there's a lot of software and applications out currently, but I think to a large extent we rely on a manual process. Yes, where contract management is successful, and I think it's, you know, it boils down to human intervention. You know, it's something that you cannot remove. You can have as good a written contract that you can find. It ultimately relies on sound interpretation, having the right person there for the job. Obviously, minimizes disputes and surprises. It's all about this fair and impartial approach. So the contracting life cycle then, it's a high risk and increasingly complex business. Yes, people, you know, I often ask myself, why are we battling with these contracts? What makes it so difficult? The thing is, these contracts do bring a lot of very specific and peculiar characteristics. Interim payments, practical completion, requirements, privity of contract, bonds, sectional completion, warranties, guarantees, defect notification periods, very different than any other contract, and that is really what makes them so complex. And then you've got all the time barring and all the administrative factors. And it certainly does require problem solving around the clock. You need to be able to think on your feet constantly. People, I just want to say that, you know, if you sit in a project meeting, I sometimes find that that is where it goes wrong. There's nothing that forces you to make a decision there and then. If you are not sure, pull out and let the other party know that you will come back to him or her. Don't make a decision if you are not sure. Go and sleep on it. You know, we as humans, it's almost like fear. Fear doesn't exist. Fear has no existence. It's all connected with the future. And I think if you take yourself as a human being, there has been many moments where you have been fearful of tomorrow. But surely when you came to that tomorrow, that next day, you dealt with that fear and you were actually worried with no real purpose behind it. So people really only experience. I was talking about knowledge, but experience, talking to your friends. And I always say to engineers and project managers, before you make a ruling, always test your ruling first with your colleague. Because we know that when it comes to these contracts, they all allow for a notice of dissatisfaction. If I'm not happy with the ruling of the engineer, a third party can decide. So make sure that you first test your rulings, because you know that there's a potential for your decision to be reviewed. The two consenting parties, consent. We sometimes refer to the Latin term animus contrahendi, the intent. It was the intent of the contracting parties to proceed in this contract. Consent. Should be mutual consent. Consensus ad idem is a requirement for a valid contract. And sometimes we now see claims, there was consensus at the time of entering into the contract, but later on things have now changed. I think we certainly do have good contracts in our industry now, but yeah, a contract is only as good as the person behind it managing it. And people, be careful of deviating from the formalities or the provisions. Because we are now seeing contractors saying, no, but 6 months ago, you did not act, but now you want to act. Yeah. The JBCC actually has a very good clause that says, the fact that I've conducted myself in this manner doesn't mean that you can hold me to that same conduct in the future. Actually a good provision. Yeah. So manage the startup, people, get the tone right. Contract administration, obviously key. And there are many tools and techniques. Unfortunately, our time is don't have enough time for that. And proper record keeping, sure. You know, sometimes I get back to the office and then there would be 10 boxes. So suddenly, a contractor or an employer wants to deal with a dispute or wants to defend the dispute. No history, no proper project records. Or they are there, but they are not sorted. It will probably set you back between 100 to 200,000 just to get that documentation in a logical order. It is also not something that you can allocate to a junior person. You need something with a bit of a understanding for what it is that they are looking for, what it is that needs to go into a statement of claim or into a reply or in a replication or into a rejoinder. Yeah. So just looking then at our contracting lifecycle, people, I'm just quickly going to run through it. So it consists out of your request phase, so obviously the type of contract that you're looking for. Then, of course, you've got your authoring, so obviously editing your existing contracts and passing, so that it passes your existing needs. Then you've got your negotiation phase, of course, the presentation of the drafts and the versions, and then the authorization of that specific contract. And there's obviously, we normally go through a contract review and so forth, and many parties plays a role in that. And ultimately, you've got go into your approvals phase, where the contract needs to be checked with the various stakeholders. So it typically relates to your contracting strategy. And then it runs into your execution, where the contract is finally prepared and the document gets signed. Looking at signed agreements, still a problem. We are still seeing a lot of contracts being performed without a signed contract, sometimes with no contract in place. We've got a letter of appointment and that is it. Yeah. So please people, yeah, a letter of intent is not a contract, eh? We saw case law. For a contract to be a contract, the judge ruled, it must smell like a contract, eh? Then you've got your obligations phase, so obviously it doesn't stop there. It deals with all the alerts, your workflow processes, your risk assessment, your spend management, your compliance monitoring, all sits under the obligation phase. And then ultimately your compliance, whether you are meeting all your contractual requirements, your relationship, and of course all of that is fully auditable and so forth. And then you've got your renewal phase if that is something that you want to proceed to. So we need to analyze, we need to agree the understanding. Sure, people, very important. So when we kick off these projects and contracts, we need to find a common ground that we can bat from. You know, it's almost like being a referee, and I always say to engineers, project managers, employers, agents, it's like being a referee in a sports game. You know, each and every referee normally have a checklist. So regardless of the type of sports game that favors you, you will find referees that they just do the basic rights, and then you've got the guys that really look after all the complexities, the more finer detail, not only offside lines and foul play, they look at other things as well. So a little bit more technical, and the same rules apply in this space. So obviously you need to identify your deliverables up front. So these days, in contract terms, we normally refer now to the requirements for practical completion and then completion. And obviously, there's a set of deliverables that comes with these contracts. And when it now comes to the requirements for practical completion, those must be listed in the contract. So all 4 contracts are now on the same path. The JBCC contract, for example, places a different responsibility, though, on the principal agent. That contract says, well, the principal agent must visit the site at regular intervals and he must guide the contractor to practical completion. We don't have that same tone in the other contracts. Roles, responsibilities must be well defined, the payment arrangements. And yes, people, when it comes to payment arrangements, sure. You know, the contract does have its standard payment arrangements. Let's take one. The FIDIC contract, for example, typically says that you will be paid 56 days, or on 56 days. So in FIDIC, it basically implies that you should be able to carry yourself for at least 3 to 4 months when it comes to cash flow. The other contracts do have a shorter payment term and arrangement. So need to confirm any specific arrangement with the service providers and then also our customer procedures. So people, I just want to say that when it comes to internal communication arrangements, that is something that shouldn't be bothering the contractor. So you've got your set time frames. So as far as the communication procedures between the project manager and the employer, that is something that the employer and then the project manager or the engineer need to smooth out. It is not for the contractor to be concerned about that time barring and communication channel. Obviously, we need to get our resources in, senior management support. So people are, you know, just talking about senior management support. One of the objectives of all 4 of these contracts are really for the parties to the contract to execute the contract. We want to become less reliant on executive involvement. To the contract documentation at the appropriate space and place in the contract data. That is really essential. We've now seen during adjudication and arbitration that sometimes we refer to documents, but they are not listed in the contract data. Highly problematic. So So the chief reason for project delays, poor contract management, therefore proper contract management is essential. But people again, in my opinion, it's really to do with formalities, not complying with the formalities, not complying with the time barring, not responding, not acting. It's normally the small little things. Not being fair, not being impartial, constantly asking for more. How much more do you need? You know, the other day, I saw in a JBCC agreement, a principal agent asking the contractor for a forensic delay analysis in order for him to substantiate his claim. Really, people, are we at that level? It's not that I'm saying that the SCL protocol is not a good thing, but those are merely guidelines. Surely, we should be able to substantiate without going to that extent. I actually responded back to the principal agent and I said to him that this was never a contractual requirement. If you now require the contractor to perform and to provide you with delay analysis and a forensic delay analysis, then you would unfortunately have to pay for that. Then we can certainly provide it to you. So let's quickly run into the NEC and NEC4. I really just felt that we should talk about that. So of course, people, the employer and the contractor are in this contract. So firstly, just talking about NEC3. So the project manager, and I think the reason why I really wanted to talk about NEC3 is because of this direct relationship with what we are doing here. So in terms of the contract, that is the individual responsible for managing the contract, and then you've got a supervisor that reports to him. So typically, if you want to talk about the site agent or your construction manager, that individual will then report to the project manager. Now, I just want to say as well, and you know, there's so many things that we can talk about. Please do not call yourself something which you are not. If you are not a project manager, please do not call yourself a project manager. If you're not an engineer, do not call yourself an engineer. I know it's very tempting, but you know, I can only give you the perspective from my end. So normally when I consult and when I provide advice, I normally already see the court papers or the statement of claim or the replication or the rejoinder. Remember, you will be measured against your profession. I had a case whereby a contractor sent his PA to attend to a site visit. The contract says, you need to investigate, you need to inspect, you need to go and examine the site. The contractor wanted to bring a claim for unforeseen site conditions. I then got the attendance register, and during the arbitration proceedings, I said to the contractor, who signed here? No, it was Longile. Ah, Longile, come. I want to talk to you. Yeah. This contract says, you must be knowledgeable. You must have skill. Longile, tell me a little bit about your project management skill. How many projects did you do? When you went to the site, what did you see? The contract says that you need to familiarize yourself. You must not only walk around on the site, but you also need to go and check next door. You need to look at site access. You need to look at water's influence on the site. You need to look at the execution area. Health, safety, not endangering people's lives and things like that. So she responded, no, I went there because I was in the vicinity and my boss asked me to go there. I'm actually a secretary. I don't have a problem with secretaries, but it's a problem under that scenario. You need to send somebody there that's knowledgeable and skillful. So, required in law to act impartially. So this project manager, under NEC, he's required also to act impartially and fair. It is only the the FIDIC contract that does not require the engineer to be impartial. It actually states that he works for the employer. But in this contract, he must be impartial and fair. He can delegate and he can instruct a change to the works information and or key date. He can also accept, reject the contractor's proposal for adding to the work area. Many things that he can do, so that's within his authority. When it comes to early warnings, he must give an early warning as soon as possible. So this is a very unique feature of NEC. As soon as you become aware, you need to advise the other party. You need to fire off an early warning. And then the parties need to come together within 2 days and discuss the matter at hand and record their findings in that risk register. Yeah. So if there's any impact on those things, we need to notify one another. And he can also instruct the intenders of the contractor at the risk reduction meeting and require cooperation in making and considering proposals, seeking solutions, and decides on the actions and decides on the risk handling. So people, when it comes to these contracts, our project managers, our engineers, our employers' agents, they are required to first consult the audi alteram partem rule, the right to be heard. So if you need to make a determination, come and talk to me. You need to listen to me as the contractor as well. If we cannot reach consensus, then, of course, you can pull away and then make a decision in isolation. You can issue instructions if any event occurs which stops the contract completing the works by a date shown on the accepted program and which neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it. Yeah. I'm now dealing, or I dealt with an arbitration case where an organ of state highly inflated weather data for some other reason, highly inflated the weather data. I then said to the project manager, I need an instruction from you. This is the data that came from the weather station, from that gauge. Your data is highly inflated for whatever reason. I don't know what the reason is, but I can tell you the fact that it's so inflated is preventing the contractor from claiming. I then asked him for an instruction. He said to me, no, I'm not going to give you an instruction. I said to him, I need an instruction. He said to me, no. Because he realized that if he gives an instruction, that instruction will also result in a compensation event. So, because in this case, it dealt with, or it resulted in prevention, or prevented the contractor to perform. So the project manager in time then should certify completion when? Within 1 week of completion. He must receive, accept, or reject the contractor's first program within the period stated in the contract data and each subsequent program, and considering the following. So you need to look at all of these things, people, all the little deliverables in terms of the program. I always say that at commencement, we do not want to influence the program too much. But yeah, you need to obviously check if it's logical, if the sequence is right, if all the interfaces are well defined, and if it's fully representative of a true critical path, that the critical path is perhaps not misrepresented, and that it complies with all the requirements, resource loaded and so forth, all those technicalities. So these are all the deliverables that must be achieved. And people, when it comes to all of our contracts now, it typically says that the program must show both float and the contractor's time risk allowances across all 4 contracts. And then any other information. So again, one of the key rules is if something is so important, if there's something that you need to bring to my attention, indicate it in your schedule. So if you need a drawing, if we need to conduct tests, or if you need to be present whenever we conduct tests, you need to inform me. And you can do so by indicating that event in the schedule. And certainly, yes, people, some programs needs to be accepted and others will need approval. The JBCC contract and the NEC contract typically talks about the program that needs to be mutually accepted. The FIDIC contract typically says that the contract or that the program is deemed to be approved until proven otherwise. So we need to read these things. You can also instruct the contractor to stop or not to start any work, or start or restart that work, and certify the date upon which the employee takes over any part of the works. So finally. Then testing and defects, we need to assess the cost incurred by the employer and repeating a test or inspection after a defect is found. Arrange access to parts of the works and consider proposal from or to the main contractor not to correct a defect. And also consider quotation from the contractor for saving as to defects or saving as to earlier completion date, and decide whether to instruct. So people, I'm really just highlighting some of the deliverables of a project manager then in terms of NEC 3 and 4. It also says that this individual must fully be familiar with the payment provisions. He should receive the contractor's application for payment. He must carry out in good time all the relevant assessments. Consider grounds for withholding sums. So of course, people, whenever we are withholding sums, we need to provide reasons. We normally talk about adequacy of reasons. So in terms of the PIA Act, it defines adequacy. So when somebody gives you reasons, it needs to meet the standard of adequacy. Must monitor and report to the employer what sums are due to the contractor, and then monitor actual transfer of the monitor and KPI and the KPIs as far as the data is concerned. So of course the parties can mutually agree to change the KPI data, but then as long as the parties reaches mutual consent. So talking about compensation events, so certainly when it comes to NEC 3 and NEC 4, we don't refer to claims, but we refer to a compensation event. So I need to compensate, and all of these events are pre-identified. So if you tick the boxes, for example, interference or change of a previous decision, there's a whole list of compensation events or events for which a contractor can claim. And of course, if the project manager fails to notify a compensation event, it will not fail the contractor to do so, or then to notify of the event. But yeah, there's a duty on the project manager. The only contract that places that duty on the project manager. I think I've spoken about the early warning procedure, people. So really the only contract that makes use of an early warning procedure. So as soon as there's any impact on cost, schedule, or performance, we need to fire off this early warning. It's really a good mechanism within NEC, and we are certainly seeing that a lot of project managers and construction managers are now also incorporating this early warning procedure. Because ultimately then you know it gets followed through a proper risk assessment, and the mitigation strategies are then recorded in that risk register. It cannot go anywhere. It's well documented. Taking a look at FIDIC. So it says that the Red Book, and of course people, we know that FIDIC has launched a new suite of contracts. The FIDIC 2017 edition has been released. JBCC 6.2, of course, is also out. NEC 4 is out. GCC 2015 has been around since July or September 2015. However, these latest versions of the contracts have not yet been incorporated into the standard for uniformity. So we are still waiting for that standard to be updated, and once it's been updated, then it will become legislation, and then our organs of state should be using the latest version of the contract. But we've now seen, you know, if we look back over the past 4 or 5 years, it certainly hasn't been the case. You know, we are certainly seeing that even the GCC 2010 is still being used significantly. Just very importantly, so if we look at FIDIC and then the role of the project manager or then the engineer, individuals like yourself being engineers and project managers or with a qualification then as both, identifies the engineer as a member of the employer's team. So this is quite a different approach. So it then certainly implies, not only implies, but it's also got an express term that this engineer is deemed to act for the employer. And therefore, under FIDIC, the project manager, the engineer, is deemed to act for the employer. He doesn't need to be impartial, but he must still be fair in his determination. So we can see that we've got these two classes. I'm just highlighting that a bit. You've got the employer's personnel, and then you've got the contractor's personnel, and then subclause 3.1 stipulate that except as otherwise stated in these conditions, whenever carrying out duties or exercising authority specified in or implied by the contract, the engineer shall be deemed to act for the employer. I must say this contract doesn't have as many deemed clauses as the JBCC contract. The JBCC contract have far more deemed clauses, and I think perhaps, I know that whenever it comes to our legal fraternity, they always look at those deemed clauses with caution. So, because in FIDIC, there's also a clause that typically says that something is deemed to be the truth regardless of the, or a fact regardless of the objective truth. So I know that our legal fraternity doesn't look so friendly upon that deemed clause. So the Red Book 99 gives the employer an express right to replace the engineer under subclause 3.4. However, the employer cannot replace the engineer with a person against whom the contractor raises reasonable objection. So yeah, the contractor can object to the appointment of the engineer, but he cannot just remove the engineer without the consent of the contractor. So this basically then implies that there's no guarantee that this engineer will remain on the project for the full duration of the project or contract period. Looking at insurance for the contractor's personnel, so people, I'm really just highlighting some of the engineer's powers and duties. So that is your subclause 18.4. Places this obligation on the contractor in also providing insurance for the employer and the employer's personnel. And then when it comes to the employer's claims, your employer or the engineer shall give notice and particulars, and then it requires the engineer to proceed in accordance with subclause 3.5. So regardless of whether you are the employer or the contractor, if you think you are entitled to a claim, you must present your claim. If you're the employer, as soon as practical. If you're the engineer, or if you're the contractor, within 28 days, then it will go to the engineer. He is still under an obligation to make a fair and reasoned ruling. Clause 3.5 in FIDIC typically deals with your determinations, and it says that each party shall give effect to such determination unless and until revised under clause 20, being your dispute resolution clause. So even if you have referred that determination to adjudication or arbitration or amicable settlement, you still need to adhere and continue executing according to the determination. And the employer is obliged to pay the interim payment to the contractor when within 56 days after the engineer receives the statement. So we can see that the payment terms in FIDIC far more far longer than any of the other contracts. So FIDIC people, we are certainly seeing that the contract is really making good inroads, and we are seeing the contract really being used extensively now at the Medupis, the Kusilis, Randwater, the Kugas, and so forth, even Transnet, Sunral, and so forth. So the contract is certainly building up some very nice momentum. In my opinion, really the Rolls-Royce of contracts. Also further considering that the FIDIC contract, the first version of the contract, was published in 1957. So really an extremely mature contract. So project management and the stimulus to good management, people. So as far as management is concerned, that also gets done through the program. So when it comes to the program and all four of our contracts, it places a high emphasis on the program. The program really plays a critical role. So we always start off with a baseline. We redline it monthly. Some of our contracts also puts a requirement for these contracts to be updated bi-weekly or every second week. But yeah. Also, you know, I've now heard in the past, where was I last week? In Polokwane, where an engineer said to me that he's battling to get a program out of the contractor. It really depends on how much detail you've put into what it is that you want. But, you know, a contractor can bring you a program on the back of a cigarette box if you haven't defined it properly. But yeah, you shouldn't be begging for a program. And a contractor needs to understand that in order for a claim to find application, he would have to submit a program. It's going to be extremely difficult to substantiate a claim without a program. Of course, the tool for managing and controlling, managing your risk, managing your cost, and also then for determining your compensation event and then your claim. And of course, people, the critical path must be, must reflect in the program, so strict formality. All four of the contracts requires that. The JBCC contract is slightly relaxed when it comes to the program. It says where appropriate, the contractor must show the impact on the critical path or on the program itself. So it does not say in each and every instance. It says where appropriate, the contractor must show the impact. So of course, people, I think the critical path in, if I can define it, I think then the series of activities with the least amount of float in them, I think if I would define it, needs to be reflective in the schedule or program. Formalities, as far as FIDIC and NEC, again, many formalities, standardized language, standardized forms across all the contract documents. The project manager and then disputes by just looking at the NEC contract then. So either an action or inaction of the project manager. It can also come as a result of any other issue. When it comes to adjudication options people, NEC only provides for a two-tier scenario. It's either dispute adjudication or alternatively arbitration through the tribunal. So those are the only two options. If there's a disagreement or if there's a dispute, you will notify the project manager. He's got then 10 days. People like yourself, you've got 10 days to look at that dispute, try and resolve it. If it doesn't get resolved in 2 weeks or in that 10 days, then the contractor can refer the dispute to the adjudication body, either one adjudicator or three adjudicators. If it proceeds to arbitration, either three arbitrators or one arbitrator, just depending on the formalities of the contract. And ultimately, we would look at termination. So option W1, that is your first step in adjudication. So that is the clause that governs the dispute resolution within NEC. And as I explained, your first step would always be adjudication, and then only can you proceed arbitration. There's no mediation, no amicable settlement within NEC. So if you're not happy with the ruling of the adjudicator, or if the adjudicator doesn't provide his ruling in time, then you can refer further to arbitration. And again, people, you cannot proceed to litigation without having exhausted the internal remedies to the contract first. Over the last week, I dealt with a client, a contract, and he said to me, Chris, I need you guys to write a letter of demand, and I want you to start with a simple summons process. And I said to him, no, we can't. We first need to exhaust all the internal remedies to the contract. And he said to me, but it is expensive. Yeah, it is expensive. You should have considered that when you entered into the contract. So, option W1, that is our dispute resolution process. The adjudicator obviously appointed under the NEC adjudicator's contract, so there's a little contract, normally a 2-page contract, deals with his tariff, and a start date, end date, little brief of the dispute. As far as the adjudication notice, the adjudicator will also receive a copy of that, and then the parties have 14 days to provide further information, and the adjudicator has 28 days for providing his reason. He can ask for more time, but then he must request that time, so he can extend it. And then you can proceed to the tribunal only when 4 weeks after the decision, following the decision. Or if there were no decision, then only. People, just wrapping up now. Just let's take a look at the project manager and disputes and the claim process under the Red Book. So the engineer acts in the interest of the employer, no longer has a duty of impartiality. So this is one of the biggest differences in approach. Has that obligation, and the employer's claims against the contract have to be made in terms of the contract. So I think what we are seeing a lot as well is where employers are acting as judges in their own cases. It concerns me quite deeply whereby a lot of our engineers and project managers are merely acting as post boxes. So not allowed to make determinations. That is really your job. Your job should be to make fair and reasoned rulings. But we are now seeing that employers don't always or are not always knowledgeable about the inner workings or mechanics of these contracts, and then they tell the project manager or engineer what decision to make. Extremely problematic. You will be seen as having acted as a judge in your own case. We need to take that matter and place it before a neutral. So, failure by the contractor to give a 28 days notice. So, of course, as soon as you become aware, or ought to have become aware of, you need to notify. Then the engineer is obliged to respond to a claim within 42 days, and the employer may claim an extension of up to 2 years of the defects notification period as well. So this is a very different entitlement, and the only contract that allows for that entitlement, specifically where perhaps there's a component or a repeat defect in the works. And it's an extension of the entire defects notification period for the entire works. So the procedure then for settlement, so everything starts with the engineer's determination. All the claims must be determined, so it's not just a matter of the employer's claims not being determined. Act on behalf of the employer, and the referring party must comply then with respective specified procedures. And once the engineer issues a determination, both parties must give effect to that immediately. That hasn't always been the case. We've also seen with the GCC contract that there was an amendment brought about as far as the adjudicator's decision. So those decisions must now be implemented immediately. No wait and see for a higher tier review. The next stop would be your dispute adjudication board. For me, it sometimes feels that the FIDIC contract is almost like the little big brother of GCC. Contracts resembles very closely in terms of character and even in numbering format. So when it comes to the adjudication board, the contract allows for both ad hoc and standing adjudication. If you decide on an adjudication board, you need to indicate that within 56 days from commencement. If not, then ad hoc adjudication will apply. Of course, the DAB members should be independent, also impartial. They can be pre-nominated or selected later. And then the DAB will adjudicate the dispute, and within 84 days after receiving the reference, a decision will be given by the DAB. So we can see an extremely long period. So only after 84 days, then you will have a ruling. Yes, you can provide a ruling earlier, but he's entitled to use that time frame. So this is the thing, people, with adjudication arbitration. It's supposed to be a speedy process. It's supposed to be an inexpensive, or rather inexpensive process. But we are seeing, I think, of all the arbitrations that we've dealt with, some of them are being determined now. Most of them we've already started in March this year. So a lot of the arbitrators are typically senior counsels or advocates, or sometimes also engineers suitably qualified. Obviously subject to the Arbitration Act, but a lot of our arbitration adjudication cases then later become subject to natural justice. The time frames are sometimes delayed. It also depends on availability of senior counsel and so forth. So we are seeing that some of these adjudication arbitration proceedings are sometimes taking between 4 to 6 to 10 months. And not the ideal economical position to be in if you are a contractor, perhaps negatively impacted. So one really needs to understand the forces and the working mechanisms of these alternative dispute resolution mechanisms. So the decision given by the DAB shall be binding, and therefore both parties must comply with the decision. So obviously, unless there was maybe impartiality or some form of bias appeared, then one would also be able to revert to court. Yeah, so maybe just in my wrapping up, I just want to also just state that even if the contract was terminated, even if the work was already done, let's assume you do pick up a dispute years later, months later, you still need to first come through the dispute resolution gates, exhaust those mechanisms, and then you can proceed to litigation. We are really trying very hard in the industry to avoid litigation. We think that there's enough mechanisms in the contract not to go down that road. And where a decision by the DABD, by the Dispute Adjudication Board has been given and no notice of dissatisfaction has been given with regards to that decision by either parties, then the decision shall become final and binding. Then you've got that cooling off process. So in between adjudication and arbitration, you've got amicable settlement. So it's a 28-day time barring provision. So that is really just for the parties to reconsider. I sometimes find this a little bit out of place, but because normally at this point, the parties are already in such a hostile space that it's very seldom that they would want to amicably settle. However, having said that, we've now had a case whereby we represented a contractor during arbitration. It was the first dispute. Now another dispute is also moving towards arbitration, and now the agent, the engineer actually came back and said, no, we don't want to go through that arbitration process again. Let's rather try and settle. But those are really far and few in between. So you cannot proceed until you have waited out this period. So unless settled amicably, any dispute in respect of the DAB decision which has not become final and binding shall be finally settled by international arbitration. Of course, people, this is also one big consideration. Remember, these international type contracts, they are subject to international rules, the arbitration rules of the ICC, the International Chamber of Commerce. And under those rules, we will appoint an international arbitrator. It will obviously lead to significant cost increase, as well as it is far more expensive. When it comes to the ICC rules, the costs for arbitration are normally a percentage of the claim or of the contract value, so it could be significant. But yeah, you know, obviously, when we've got these international contracts, you would want to arbitrate on neutral ground, neutral rules. And then, of course, we've also got the International Arbitration Act that came into operation in January of 2017. So when it comes to arbitration, people, it is normally the claimant who will put on the initial cost. Yes, you can ask for costs to be shared. It's very seldom that the arbitrator will do something like that. They might try to, live up to the principles of natural justice. Yes, you can also ask for compensation when it comes to calling of witnesses and their expenses. But normally the arbitrator will divide the cost between the two parties. In some instances as well, if the one party cannot contribute to the cost or doesn't want to contribute to the cost, they will make a ruling for the other party to pay that cost, and then for the other party to try and recover from the party who defaulted on the payment. So at least you can then get your ruling, because remember, an arbitrator or adjudicator can withhold the ruling until paid in full. People, yeah, I think I've spoken about setting the tone. I don't think there's anything further that I can add at this point. For me, I think really the way to go, we need to talk about these contracts, and we need to specifically inform one another how we're going to work with one another, and how we're going to implement and interpret. And that is absolutely essential at your project kickoff meeting then. So, having just scraped the surface a little bit, if I can call it that, I normally spend 2 to 3 days on a single contract, whereby we really drill down into the mechanics. Yes, I think that is it from me. So I want to thank you for also giving me the opportunity to attend, and it was great meeting all of you. I'm not sure if I was given some evaluation forms. I will quickly check. But I believe you guys will be earning some further CPD points through your attendance. So I think just a last word from myself before we depart then. Do not bully, and do not allow to be bullied. Stay neutral, and let's see if we can at least get everybody on the same space when it comes to the interpretation of these contracts, and let's see if we can resolve our disputes without having to seek redress from our courts. I think there's enough mechanisms to do so. I thank you.